I will go ahead and turn it over to Attorney Jason Brown for an overview of family law procedure. Take it away, Jason.
All right, thanks very much. Appreciate that. And good afternoon, everybody. It's great to not see you. I'm staring at a computer screen, of course, with a camera. And I wish it weren't this way. I think we all do. But hope to give you some practical insight and good information about family court procedure. When I was approached to present, um, the information I was provided kind of indicated that it would be really helpful for the clerks to just sort of get a big picture overview of how family cases are processed and to talk about the burdens of proof associated with different facets of a family court case. So my aim this afternoon is to give you that overview. I do have this PowerPoint presentation that hopefully you can use in real time, but then we'll make it available to you, after the presentation as well. So we're really kind of taking a 50,000 feet look at family court, family procedure, try to give you some sense of perspective anyway of where you might find yourself within any particular family law case. The information I'm providing to you is just based on, of course, the law. It's also based on the fact that I've been a family law attorney now it has been 20 years. And so it's just based on my own experiences and hope to give you some insight that will help you as you navigate through the waters that are known as family law. Thought it might be important to start with kind of a general scope of what I consider to be a family law case. The predominant type of case that falls under the umbrella of family law is a divorce. But there are also paternity cases, cases involving post-decree relief, both in terms of a divorce as well as a paternity file. Third-party custody cases, where you've got someone who's not a parent who's seeking either custody or some sort of time with children. Grandparents' rights cases, as well as domestic abuse. And then I've included harassment, not necessarily because it is a de facto family law area, but just to include it because it's been my experience that a lot of divorcing couples will petition for a harassment restraining order against one another. And so I thought it might be helpful to give you some insight about that as well. Big picture on divorce work, and it's been my experience about 80% of the family court cases that are filed relate to divorce. And so we're going to spend probably a good 60, 70, 80% of our time this afternoon talking about divorce. But the good news on divorce is that about 50% of the time, cases that come the direction of a lawyer wind up getting settled before the matter even gets filed. And so it is not uncommon for you as a law clerk to receive a packet of materials that basically have been produced as a result of ongoing settlement discussions. Those materials include a proposed judgment and decree, all the initial pleadings in the case, everything sort of gets thrown at you at once. And of course, the other half that don't settle through direct discussion, we wind up resolving by filing with the court. In terms of a divorce, kind of going back to first year Civ Pro, the same concepts of jurisdiction apply in a divorce as in any other civil action. There needs to be both subject matter jurisdiction over the marriage itself and personal jurisdiction over the parties. Subject matter jurisdiction is vested in any litigant who has lived in the state of Minnesota for at least 180 days. So the threshold to cross over into subject matter jurisdiction is not necessarily complicated or difficult to do, but it does need to be in line with that 180-day rule. Personal jurisdiction is a little different because the concept of personal jurisdiction, of course, rests in having authority over someone who either is a resident or is located in the state of Minnesota. And in that situation, it's actually fairly straightforward. But occasionally, you have someone who doesn't live in state but is married to someone who lives in state, and that someone has lived here for at least 180 days. And so the question of personal jurisdiction comes up quite regularly. With that, if you've got an out-of-state litigant, I think the important concept to understand is this, that the court does have personal jurisdiction via the long arm doctrine over someone's marriage, even though they don't live in Minnesota, and over their children if there are custody disputes. But any other issues involved in a divorce in a traditional sense, things like spousal maintenance or a division of assets and debts, the court does have to have actual long-arm jurisdiction to have personal jurisdiction over an out-of-state resident. So what we often see is that there's a discussion with the other litigant where we talk about this idea of, hey, you can choose to go down the path of disputing personal jurisdiction, in which case they would have to initiate a separate court action in a different state, or they can simply acquiesce and agree that Minnesota will have personal jurisdiction. Most often, that's what winds up happening. Venue for a case in the state of Minnesota, pursuant to statute, is in the county in which either of the party resides. And there are occasions where litigants will try to county shop. Back in the day, there was sort of an unwritten consensus that there was this broadly different approach that one county might take over another. Kind of the classic example was, again, this is sort of outdated, but 20 years ago, there seemed to be this wide disparity between Hennepin County and Anoka County, both of which, for those of you that aren't familiar with the Twin City area, they border each other, and all you have to do is cross the Mississippi River to get to one or the other. And the way that parents were treated in one county was viewed as being very different than in another. And so on occasion, we would have people that would intentionally relocate, from Champlin up to Anoka and live with a friend and then file in Anoka, or vice versa, depending upon which was more beneficial to them. It doesn't happen all that often, but when it does happen, there is a legitimate question about what county do we want to bring the action in. And most often what I find, it's more today about procedures and options available through alternative dispute resolution and things like that. But just know that the county in which either party resides can serve as venue, and there can be a fight to the courthouse, a dash to the courthouse steps to get matters filed in order to, try to get a leg up on the other side. In a divorce, the parties are known as a petitioner or a respondent. They're not known as a plaintiff or a defendant. And even though there are, little different terms that apply, rules regarding service of an initial petition are the same rules that apply in any other civil action. Rule 4 of the Rules of Civil Procedure require personal service upon the actual litigant. Subsequent to that, there can be service by mail of different pleadings, but when it comes to that initial petition, those Rule 4 standards do apply to a divorce petition. And of course, we are a no-fault divorce state. The way that I explain that to most folks who contact me is that it doesn't necessarily matter to the court what leads to a breakdown within the marital relationship. The court is not going to reward or punish one party or the other for either being the petitioner or the respondent, or for engaging in acts during the marriage that one might consider to be sinful or inappropriate. Of course, there are exceptions to that. We find that sometimes fault will creep into, for example, a case involving custody or parenting time issues. If alcohol is a problem for one of the parents and alcohol impedes their ability to adequately care for their children, and alcohol also led to a breakdown in the relationship between the parties, fault does sort of creep in. The idea that someone has engaged in behaviors that are inappropriate will, of course, impact the outcome involved in the case. But that's not to say that alcohol use alone will create a result that is favorable to one party over the other without more information. In any divorce, there are 5 key issues that need to be addressed: the issue of custody, child support, property division, spousal maintenance, and attorney's fees. Clients do have the ability to seek an award of fees as part of a divorce. Looking at each of these, again, from a 30,000-foot level, there have been other presentations that I've been a part of where we've talked, for an hour just about the basics of property division or some other narrow issue. But as a starting point, the best place to look for guidance in terms of custody issues is 518.17, subdivision 1. Those are the infamous 12 best interest factors. Those factors include things like a party's role in the upbringing of a child's special needs, whether there have been incidents of domestic abuse and the nature and context of that abuse, the wishes of a child if they're of suitable age and maturity, things like that. And so they're there for you to digest. Do know that it was just a couple years ago, well, probably 3 or 4 years ago now, I think it was 2016, when there was a major overhaul of those best interest statutes. And so to the extent you might be relying on old case law or old statutes, you want to make sure you're looking at the most current version of 518.17 to provide guidance regarding the factors that are the most pertinent for a determination on custody or parenting time. Regarding parenting time, I think the key with parenting time is this, that there is at the present time a 25% minimum rebuttable presumption regarding parents and their ability to care for kids. And what we're talking about is the percentage of overnights. The child support statutes take into account the number of overnights in determining what the amount of support will be for one parent versus another. And so when the statute speaks of mandatory minimums or 25% as a rebuttable presumption, it's the overnights that are being counted. And of course, that is a rebuttable presumption. If there's some reason for the court to deviate from that number, they will. For example, if an individual frequently works out of town for weeks on end as a salesperson, obviously there's a reason not to grant that parent the full 25%. But the battle lines most often are drawn between 25% and 50%. It's never a 0 to 50. So just know that the nuance that goes into a parenting time schedule usually involves something from between 3 to 4 overnights every couple of weeks to 7 overnights every couple of weeks. And it makes a big difference in not only the child support, but in how people view the righteousness of the parenting time schedule that's been created. With regard to child support, there is an entire chapter within 518. It's 518A with a series of statutes that address child support specifically. These statutes were changed, it's been now 13 or 14 years ago, to take a look at an income comparison approach to child support. In addition, the statutes were tweaked a little bit about 2 years ago, where one of the predominant factors was the number of overnights that a parent would have with a child. As of a couple of years ago, the rule was this, that if you had between 10 and 45% of the available overnights, you landed in the same category with regard to a credit against what your child support obligation would be to the other parent. And there was some inherent unfairness in that. Parents that had time with their children 10% of the time were treated the same as a parent who had the children 45% of the time. Obviously, there's a wide disparity in the involvement and therefore the expense involved with parenting. So 518A and all of those statutes, will direct what is to happen with regard to child support and provides guidance. A couple months ago, I had a presentation for you all that talked about property division, and we talked for a good hour or so on that. But as a starting point, the major concept in Minnesota is that there will be an equitable division of all assets and debts. And what I tell clients is that equitable almost always means equal. With that in mind, I can refer you back to the recorded seminar from a couple months ago if you want to learn more about that. But statutorily, that equitable language is contained within 518.58. The issue of spousal maintenance or alimony, they mean one and the same. Alimony is a payment that a higher income earning spouse pays to a lower income earning spouse following divorce. And the balance that goes on with regard to alimony is one's need for spousal maintenance against another's ability to pay. I could talk for an hour or more about alimony and all of the nuances that go into it. But the general concept is this, that if someone doesn't have enough income to meet their monthly expenses after a divorce, and the other party has the ability to assist them with meeting their monthly expenses, they've demonstrated a need for spousal support. And therefore, the court will consider the 6 or 7 factors that are outlined in 552, which include things like how long people have been married, the health of the parties, the age of the parties, the lifestyle they had during the marriage, things of that sort. It's a formula that actually it's a non-formula. It's a factor-based award rather than a formula-based award, where child support is based on a mathematical equation and is real easy to figure out. Alimony is based on a whole host of factors, and you can get 10 different answers from 10 different judges on the same facts. But just know that 518.552 is there and puts the burden on the parent who seeks, or the party who seeks an award of spousal maintenance, with demonstrating that they do in fact have that need, and that the other side has the ability to pay. Attorney's fees, again, this is a big picture type seminar, but what we've got is a statute, 518.14, that talks about the fact that there are 2 types of attorney fee awards in Minnesota. One is a need-based fee award, and the other is a conduct-based fee award. The need-based fee award is a lot like the same sort of thought that goes into spousal maintenance. The question is, does a party, given their resources, have the ability to pay for their attorney's fees? And if they don't, does the other side have the ability to contribute to their attorney's fees? It's been my experience that in the vast majority of cases, the court will decline to award need-based fees unless there's a really significant disparity in income between the parties. An example I use a lot is I represented a surgeon, 10, 12 years ago, and his income was around $500,000 a year, and his wife worked as a chef making $30,000 a year. Even with that wide disparity, the court in that case elected to grant wife a need-based fee award of about 1/2 of her fees, but still held her to pay for the other half. And so I've taken that as a sign, and it's kind of played out, that judges tend to be somewhat reluctant to do anything other than sort of a, each side pays their own way type of thing. Again, unless there's a wide disparity in income. Conduct-based fees, I find, are even more rare than need-based fees. Conduct-based fees are fees that are awarded because one party is unnecessarily contributing to the time and expense associated with the proceeding. A lot of people have differing views on that. Clients think that because their spouse is arguing over the merits of something, that they're acting in bad faith. But that doesn't constitute bad faith. If they've got a colorable claim one way or the other. That's not the sort of conduct that the court is going to get upset about. What the court gets upset about most often, in my view, are things like repetitive litigation, especially when there's been, an order that was already issued on the subject. If it's, let's say, a temporary order and the litigant comes back and tries to fight it and go back a second time, and the request they've made is just, without merit. Or in a contempt proceeding, quite often I find that if one party post decree is not following the terms of a court order, conduct-based fees are awarded because that party's conduct, the failure to abide by a court order, got the best of them and wound up costing the other side, a whole lot of money. One example that comes to mind that I hope this individual kind of learned his lesson on that. I represented a party in a divorce. It was post-decree. Everything was done. And her ex-husband was refusing to pay his share of some medical bills. And the medical bills, they maybe constituted $500 or $600. And they were medical bills that were incurred at Children's Hospital. And despite that, husband came back and tried to dispute that he should have to pay any of these bills. He refused to pay them, saying that our client didn't give adequate support for the fact that the bills were legitimately for the kids. And, the court in italics put, from Children's Hospital. And basically what wound up being a $500 dispute resulted in a contempt finding against husband. And he wound up paying about $8,000 in conduct-based fees. And so it is not unusual, although it needs to be a very narrow set of facts and circumstances, for litigants who just don't know how to behave themselves and abide by court orders to be subject to, some pretty stiff sanctions, and the court will try to teach them a lesson. So let's talk about the process of a divorce. There's, 10 or 11 steps that we as lawyers are embarking on. And the good news for the judiciary and for you clerks is that the family law community of lawyers, I would say perhaps 95% of us, are sort of the same mindset. And the mindset is this, that let's try to work together and not throw gasoline on a fire and make matters worse than they already are for people. Common sense prevails, logical discussion, respectful dialogue. Most often we're able to accomplish that outside of the four walls of the courthouse. Maybe 5% of the profession has a different approach, but the good news is that the vast majority of the time, we lawyers are working as hard as we can, with encouragement from you and from the judges and referees, to try to resolve matters. I think it's universally accepted that if the parties can avoid going to court, it's more likely they will abide by the terms of their agreement. It's more likely they will walk away more satisfied than if they're told what to do. We know they will save a ton of money, and we know that they will control the outcome. So that's the speech that's going on behind closed doors, thankfully, in most lawyers' offices these days. It wasn't always that way. So the initial case management conference, let's say that a case gets filed. As you all, or many of you probably know, that first step is that initial case management conference, where we come in, and the way I describe it to clients is it's kind of a meet and greet with the court, get to know the judge who's assigned to the case or the referee who's assigned to the case, and then really talk about procedural options. Talk about the fact that litigation can be expensive and it can be unpredictable and it can be time consuming, versus going through and embarking down a path of alternative dispute resolution. And after having that conversation with the parties, there's also usually a discussion about conducting informal discovery at the onset of the case. The idea that the court expects people to try to work together, use common sense, disclose what needs to be disclosed, and not play games with one another. Once that initial case management conference takes place, parties are given the option of taking the step of participating in what we call E&E, or early neutral evaluation. The vast majority of the time, I would say better than 95% of the time, the parties will either opt into early neutral evaluation, or they will embark on, going to a private mediation session or something like that. There's been a radical culture shift in family law in the last 20 years. When I began practicing, E&E did not exist. I mean, mediation was the only option. And so what would happen is that parties would basically be left with the choice of gearing up for litigation and instantly bringing motions for temporary relief, immediately putting people at odds with each other, completing affidavits that were meant to make themselves look as good as possible and the other side look as bad as possible. And it became adversarial right from the get-go. That tide changed in about 2002 or 2003 when Hennepin County became the first in the state to adopt and create an early neutral evaluation program. And there are two types of early neutral evaluations. One is a social early neutral evaluation, social meaning custody or parenting time related issues, issues involving kids, and a financial early neutral evaluation involving finances, things like child support, division of property, and things like that. And what goes on at these early neutral evaluations is, I find fascinating and sometimes miraculous. People who are at odds with each other, who weren't able to resolve their case before filing with the court, divert and participate in these processes. And the difference between early neutral evaluation and mediation is that early neutral evaluation is evaluative in nature. You've got these individuals who are on the list of qualified providers. The rosters in each county differ, but the common thread is that the individuals who are serving as early neutral evaluators tend to have a good amount of family law experience. They want to serve on the panel. They've been trained to serve on the panel. And then what happens is, they manage the case kind of standing in the place of the judge for a segment of time, maybe 30 or 60 days. And that early neutral evaluator will talk to the lawyers, talk to the parties, and arrange for a session. A social early neutral evaluation is done with a male-female team to avoid the perception of gender bias, whereas a financial early neutral evaluation is done by one evaluator, either a lawyer or a CPA. There's a number of good CPAs on the list that help families through these types of issues as well. It's a structured process. The parties, it's been my experience, are really engaged. So are the lawyers. They're actively working towards reaching agreement. The evaluator is there to absorb the information in a very structured way and then provide feedback. And about halfway through the session, they flip hats. And instead of being evaluative, the evaluators become neutral. They become facilitative. They move away from their own opinion and they say, all right, given what I've shared with you about my own experience, what would you like to do with that information? Do you want to resolve this? And there's a settlement success rate of about 75 to 80% with early neutral evaluation. If you can imagine 20 years ago when early neutral evaluation didn't exist, what sort of a caseload the court would see with regard to litigation, not because necessarily the parties were at odds with each other, but because they really had no other option. It's a great, great tool that now I believe has been adopted statewide. Which brings me to this. If a case were to settle after an early neutral evaluation or anywhere else along the path to resolution, there's really just a couple of steps that have to occur from the court's point of view. The lawyers will draft up the judgment and decree, which outlines all of the details of the settlement agreement. In some cases, there needs to be an administrative review where um, paperwork can be filed and the judge simply reviews the paperwork without having the parties come into the courtroom. That can happen if their case does not involve children by statute 518.13, or if both parties are represented by a lawyer. If the case involves kids and there's only one lawyer involved or no lawyers involved, then the court will have the parties come into the courtroom and just sort of have a 15 to 20-minute conversation to make sure that everybody's on the same page. I think judges use it as a way to kind of size people up, make sure that everything appears on the up and up, and that the parties can be civil to one another. I've had a few occasions where in a default hearing, the parties were still bad-mouthing each other, and the court kind of took issue with it and really questioned them and said, can you really do this? Do you really think you're capable of co-parenting? Because they weren't seeing any hint that that would happen. But most often, it becomes a quick review of the paperwork, questioning the litigants a little bit, putting it on the record, and being done with it. In the event that litigants, and keep in mind, half the cases settle before we file, and we just put together that packet of materials that I was just referencing. You might just get all this stuff right up front. The other half that don't settle, they go to early neutral evaluation. 75–80% of those resolve. That leaves about 10% of the time where cases are destined to go down a litigation track. And the next step, once you've gone through the early neutral evaluation phase, is to bring a motion for temporary relief if there's disagreement about who's going to be in the house temporarily, about what the temporary parenting time schedule will be, about support, child support. One parent is not helping the other with payment of expenses, things like that. There's a couple of ways that judges have afforded, or referees have afforded litigants an opportunity to raise such a motion. Most often it's done formally, where there is a formal notice of motion served. There is an affidavit supporting that motion that is provided to the court. The Rule 303 timelines apply to these types of motions, where the moving party, it's now 21 days. It used to be 14, but now it's 21, have to serve their papers. The other side, if they're raising a new issue, has to respond 14 days prior to the hearing. And then if there's no new issue being brought, the responding party can respond 7 days prior to the hearing. But it's an actual motion. You go into the courtroom, you argue the motion. I'm sure many of you, if not all of you, have seen these take place. But back when it was commonplace for these types of temporary hearings to take place, again, it was a very different culture. You probably don't see nearly as many as you would have 20 years ago, and that's a good thing for everyone, for the court system, for you, for the parties, and for the lawyers. We can focus more on constructive things, settling cases rather than litigating. Some judges have even taken this a step further and have used their discretion to say they don't want to have a formal motion. If someone wants to bring a request for temporary relief, there are any number of judges or referees down in Hennepin County in particular, it's been my experience, they just say, give them a 2 or 3 page letter outlining the issues, and the other side can reply. And then maybe the court will take 5–10 minutes with the lawyers on the phone and just say, look, what's going on here? Tell me what's happening. And then issue a temporary order based upon that. Now, the reason they can do that is because temporary orders are by nature non-appealable orders. These orders don't have to contain the sort of findings of fact and conclusions of law that you might see in a final judgment and decree. Instead, really the only thing that has to appear, although some judges take a more robust approach, but all that really has to appear in a temporary order is what's the order part of it. There don't need to be any findings whatsoever. And so, in light of that, folks can be creative. And again, as a cost-saving measure, be allowed to come in and do this by letter brief or phone conference or something like that. To the frustration of many litigants, temporary orders, it's just important to point out, they are not appealable. So under Rule 103.03 of the Rules of Appellate Practice, you have to have a final order if you are going to appeal something. Temporary orders, unless there's some really novel, issue you want to bring up on sort of an interlocutory basis. I've tried it once; it failed miserably. You're not going to get out of a temporary order. You got to wait for that final judgment and decree to be entered. One thing that comes up quite regularly are emergency motions. And what I tell clients most regularly is that emergency motions are treated like the very thing they are described as, emergencies. And I explain to clients that what a court might think constitutes an emergency is probably very different than what they think constitutes an emergency. I've had clients who've wanted to file an emergency motion because they don't agree with how the other parent is feeding a child, or there are disruptions in how the parenting time exchanges are taking place. Can't we get a motion right away? Tell the judge about this right away. And generally the answer is no, that's not an emergency. The audience for an emergency motion, both all of you as well as the judicial officers, are used to dealing with the most challenging and trying types of issues that humanity can face. A judge who just concluded a first-degree murder trial is not going to consider someone's concern about how a child is dressed to be an emergency, right? We tell people that they've got to think about who their audience is. But certainly there are circumstances where emergencies come up. Someone takes a child out of state without an intent to return. Boom, we file an emergency motion. Someone is maintaining a residence where there are drugs and drug abuse going on, drug sale, and we've got ample evidence that that is happening. We would certainly file an emergency motion under those circumstances. It's those types of things that would put a child in danger, and so that's really what we're looking at. If someone's going to file, there's a rule, Rule 303.04, that needs to be abided by. I know this rule well because early in my practice, I had to redraft some things because I wasn't compliant. So, Rule 303.04, it speaks of the fact that sometimes you can make a motion ex parte, other times you've got to provide notice to the other party. And usually, notice needs to be provided. It's a rarity for the court to say you don't have to give the other side your pleadings prior to seeking this emergency relief. The contents of the moving papers, there are some very specific things that the affidavit must talk about. It must talk about things like what relief is being requested, why is it an emergency, has it been requested before, if it has been requested before, in front of who, and things along those lines. So you'll want to, if you get these emergency motions, you'll want to look to Rule 303, and a fair percentage of them probably are not going to include everything that needs to be included in that affidavit. And then, of course, hearings. Just because someone files a request for an emergency motion, the order that they get on an emergency basis is not a sort of quasi-permanent order. It's just enough to get you from point A to point B. The order that gets issued gets you to a hearing date. There has to be a hearing date within 14 days. And so due process and one's right to be heard and receive notice certainly applies. But if there is, in fact, an emergency, you want to look carefully at 303.04 and make sure that all of those pieces have been hit as part of the process. So discovery goes on in divorce cases under the same rules that apply to all civil cases. If it's a corporate litigation issue about a contract, if it's a personal injury case, or if it's a divorce, the same rules of discovery apply. Most often the tools that we use are interrogatories, a request for production of documents, or depositions. The bad news is that the rules regarding discovery, because they apply universally, are not tailored to family court. And as a result, people can get stuck in the discovery machine where the other lawyer might just take advantage of all of these different rules and create all sorts of challenges and difficulty for the other party, when the reality is that a few credit card statements, a few bank statements, some pay stubs, and copies of tax returns are all the documents that are needed really as part of many divorces. So these rules are subject to abuse. And I would say more so in family court because most family law attorneys are not as well versed in addressing complex discovery disputes as civil litigators. They live and breathe this stuff. We as family lawyers don't. On the flip side, there's a very small percentage of cases where formal discovery takes place. Most of it is done, amicably with the other attorney. And so we don't encounter a great deal of problems. But when you do have that lawyer who is, in my view, abusing the rules, it can become quite frustrating because they have a right to use these tools, but they don't necessarily work the best for families. Experts involved in a divorce case, what we see quite often are, of course, custody evaluations taking place, appraisals, or what we call vocational assessments. Someone who is scrutinizing someone who is seeking an award of alimony, their ability to earn an income, what types of jobs are available in this area, given their qualifications. So assuming that the parties went to early neutral evaluation, they didn't settle, they went to a temporary motion, they've got a temporary order, they did discovery, the next step is a pretrial conference. Typically takes place, I would say, around 60 days prior to the trial date. The purpose of a pretrial conference, as most if not all of you know, is to bring the parties together, use the four walls of the courthouse to put some pressure on them, see if we can settle the case. And every judge treats pretrials a little differently. In the wake of COVID, a lot of these are taking place online through video conference. And so not every pretrial now is the same as they once were. Some now are more of a brief check-in. But in the traditional sense, the expectation is that parties will spend a good 3 or 4 hours at the courthouse negotiating, focused on settlement. And the judge is available to talk with the lawyers if there's a dispute about an issue, to try to see if they'll show their hand a little bit and give some insight into what they might do with the case if it went to trial. The next step, again, another way of trying to resolve cases, settlement in family court, is a moderated settlement conference following the pretrial. A moderated settlement conference quickly is just kind of like an early neutral evaluation where you get an evaluative opinion and whatnot, but it's done very late in the process. So we kind of refer to it as late neutral evaluation. What we find is these evaluators are really pushing parties, now that all the evidence is out there, the expert reports are complete, to really give a strong opinion about what the merits are of their case and whether they're going to succeed or not if they wind up in court. And judges generally make themselves available to assist the parties through that one last-ditch effort to try to avoid a trial. If there is a trial in family court, it's always to the judge. There is an exception in paternity cases. You can have a jury trial in a paternity case, but I've never seen it happen. I've heard anecdotes, though, 1 or 2 that have happened. But generally, a divorce case to the court, lawyers will generally work together to coordinate exhibits and try to minimize duplicity. They'll put things in binders, make sure that they're ready to go and marked ahead of time. And most of the time, lawyers are pretty good about stipulating to what exhibits are coming in so we can save time. The court has discretion, of course, to manage the courtroom and the amount of time. Some judges are rigid and say, look, the parties have 2 days. I'm giving each of them 6 hours of time to try their case. Use it as you will. And they've got 2 stopwatches going. I've seen it work really effectively. Other judges are a little more flexible. They want to give people every opportunity to share whatever it is they want to share. They don't necessarily try to put pressure on them to speed things along. The court will ask the parties to submit proposed findings. Once that is done, the matter goes under advisement for 90 days. Court issues a decision, and then there's, of course, entry of the judgment and decree with the court administrator. Then post-trial motions. There are three post-trial motions that we encounter most often. A motion for amended findings, a motion for a new trial, and a request for a motion for reconsideration. Let me just hit on each of these briefly. A motion for amended findings. What the proponent of a request to amend findings, the burden they have is to show that the factual findings of the court are inconsistent with what the record would suggest is appropriate. It's not an opportunity to come back in and re-argue the case. It's not an opportunity to take issue with specific decisions that the court has made. It's more or less there to tweak if there's an error in the order or something that's missing in the order, to have a chance anyway to have that corrected. It's been my experience most motions for amended findings fail miserably because you're asking the very same decision maker who just dedicated hours and hours of their time to not only try the case, but then issue these lengthy written orders to now throw that all out and start over. So the odds of success are not good. Same with the motion for a new trial. You're asking the very judicial officer who just tried the case to try it again because some piece of evidence shouldn't have come in. We don't find a lot of those errors committed in family court because most of the evidence is stipulated to ahead of time. And then request for reconsideration. It's kind of like a request for amended findings, except you have to have permission. You got to write a letter to the court. Then the court can say, yes, I'll give you permission to file your motion to reconsider, or I won't. And then, of course, once that's done, there's the appeal. You have a right to appeal any decision of the district court. It's got to be a final order, as I mentioned earlier. And even the Court of Appeals has now implemented a mandatory mediation process. And surprisingly, half of the time, cases that go to appellate mediation wind up getting resolved. There are exceptions. If the case involves domestic abuse or something like that, the court may not require it. But by and large, at every stage of a family court case, a divorce case, settlement options are explored, and ADR strongly encouraged, if not ordered. So we talked about divorce, and we probably did spend about 80% of our time together, 75%, kind of, talking about that. The next type of a case that is involved in family court is a paternity case. And there are three main issues that we deal with in any paternity case. There's the adjudication of the paternity of a child. And again, paternity is a case where a child is born outside of a marital relationship. Child has a mother and father. We need to figure out who is the father of this child. And we need to figure out, is there any child support that's due and owing? And we have to figure out, does that father wish to have any custodial rights or parenting time? So the custody and child support pieces mirror what happens in family court and divorce cases. So I don't need to really kind of hit on those again. But it's safe to say that the adjudication piece, the adjudication of parentage, can take place in one of two ways. Either, and this is the most common, the parents of a child will sign something called a recognition of parentage, where they're at the hospital, the baby is born, they sign a document that says that father is the father of this child, and it's notarized, and if it is sent on to the state. The execution and filing of that document in and of itself is an adjudication of paternity. So there's no need for a further court order granting father recognition as father if that is on file, the ROP, R-O-P, the recognition of parentage with the state of Minnesota. If there's a dispute about parentage, there can be an order for genetic testing to occur. And, in the era of 23andMe, genetic testing is not necessarily an anomaly anymore, but there are agencies that, there are agencies in town that do genetic testing with the approval of various courts. Post-decree motions. In a divorce or a custody or parenting time paternity case, there are 4 or 5 main motions that can be brought. A motion to modify custody or parenting time, to modify child support or maintenance, or to move out of state with a child. Just know that property division motions post-decree are generally denied and thrown out immediately because the law says that property division is final once the judgment and decree is signed and executed. So you can't come back and relitigate an issue on property division. Custody modifications, one of the most difficult things to do in family court. There are 4 factors that will be taken into consideration. The moving party bears the burden of showing that there's been a significant change in circumstance, that since the issuance of the last custody order, that it's in the best interest of a child to modify custody, that the child is endangered in the care of the other parent, and that becomes the crucial piece, or that they've integrated into the other parent's home, one or the other. Endangerment is, again, literally danger. If a child is being abused, if a child is being exposed to overt drug use, things along those lines. Integration involves, a child with permission of the other parent moving into the house of the non-custodial parent and then living there for a time. Typically, it's about 6 months at a minimum. After about a year or so, that's when we would encourage a client to file a motion if they wanted to modify custody. And then in addition to those first 3 factors, the benefit of the modification needs to outweigh the burden on the child associated with that. So that's located at 518.18D. It's also known as the Nice-Peterson standard. Custody cases generally, with regard to modification, always address these 4 factors. But there's a difference between a parenting time modification and a custody modification. Custody deals with the labels. Parenting time modification involves the schedule and the schedule only. And there are 2 different standards that apply here, both of which are within 518.175. If, and it used to not be this way, but if a parent is seeking to modify parenting time to somewhere between 45 and 55% of the available time. In other words, if right now they've got 30% and they want to make it 50-50, a best interest standard applies. They do not have to prove endangerment where they used to. 3 or 4 years ago, the law changed on that. So it's a best interest analysis. So quite often you'll see parties coming in and just trying to demonstrate that it is in the best interest of a child to modify to an equal access schedule. Whereas if a parent is coming in and saying they want to flip the schedule, they might try to play the game of, well, I'm not going to modify custody, but I want 70% of the time, even though I'm not the sole physical custodian. That triggers that endangerment standard again that we find in 518. There's also a piece in the statute that speaks about interference, rampant interference between a parent-child relationship. That can also form the basis for the court to restrict parenting time or to award a parent more than 55% of the available time. Child support modification, there's a statute that speaks to this. The basic standard is that there needs to be a substantial change in circumstance. The measurement of that is at least a 20% differential in the new support amount and at least $75 a month. If you can show those 2 things to a judge or a referee or a child support magistrate, you can succeed in modifying support. The idea is to keep people out of the courthouse if they got $1 an hour raise, right? And the new support calculation would be minimal. We want it to be meaningful enough to justify involvement of the court system. Maintenance modifications, same thing. People can seek an award of alimony, and then if they're awarded it, modify it later. It's the same standard, a substantial change in circumstance. However, that 20% $75 monthly amount threshold does not apply to spousal maintenance modifications. If a parent wants to relocate out of state, there are some best interest factors that apply. It's a different set of best interest factors than the initial custody determination factors, but take into account things like, why does a parent want to move? Are they trying to deprive the other parent of a relationship with the child? what's the feasibility of maintaining the same type of relationship between a parent-child if the relocation request is granted? Um, what type of, historical involvement there's been in the parent who would remain in Minnesota. Just know that there is a standard that applies at 518.175 with those different factors. We've got about 5 minutes left, and so I'll kind of breeze through some last minute things here. These types of cases don't come up all that often, and so we'll spend a little bit of time on it as all. Third party custody case, let's say that you're a third party, you're not a parent of a child, but you want to have parenting time or custody of a child. You have to have standing to do that. And standing is proven by a clear and convincing standard, either that you are a de facto custodian within the definition that is cited here at 257C.01, that you've basically cared for a child for a prolonged period of time without the other parent or a parent being involved, or you're an interested third party. And there's a statutory standard for that that speaks of, neglect, parents willfully ignoring their obligation as a parent. Just know that you have to have that standing in order to move forward. Once you have standing, which you have to prove by clear and convincing evidence, then a simple best interest standard applies, and it's by a preponderance of the evidence. So the biggest challenge in a third-party custody case is getting the standing recognition, the recognition of standing so that you can actually bring the claim. Same thing with grandparent visitation. Grandparents often feel like they need to get a court order granting them parenting time, or grandparenting time as it were. They have to have standing as well. Standing for grandparents comes in one of three forms. It can either be because a parent has deceased and they now wish to ensure that there is adequate time to spend with the child. It can be because there's a pending court action, like a divorce or a custody case, if they want to get into it, or that a child has lived with them for a certain period of time. And once they have standing, then it's a mere preponderance standard in terms of showing that it's in the child's best interest to give them time. But they also have to show this, and this is crucial, that there's been no interference, or there will be no interference with the parent-child relationship in granting a grandparent the right to visitation. Some grandparents have strong worldviews and they try to impose their views on their grandchildren over the objection of a parent. And generally speaking, there's special deference accorded to the wishes of parents over grandparents. And so if the court were to find that the time between a grandparent and grandchild would result in some interference intergenerationally about how those parents want to raise their kids, that could be detrimental to a grandparent seeking time. And the grandparent has to prove by clear and convincing evidence that the grandparenting time would not lead to any interference in that parent-child relationship. So it's a challenging standard. Again, I included orders for protection and harassment restraining orders under the guise of family law. The takeaway is this: just know there's an entire statute that speaks to domestic abuse. You have to have a family relationship. The Domestic Abuse Act defines what domestic abuse is, and it's located at 518B.01. And then harassment. There's two types of harassment under the law. Harassment is a crime in and of itself. I've got the site there. It also can lead to a civil action for harassment to seek a restraining order. And in both a harassment restraining order and order for protection case, there's the ex parte filing of allegations. Then the court will give the person who is the respondent an opportunity to be heard on those issues. And that's it. So we just ended with about a minute extra. Are there any questions? And I can sure stick around after the hour here to answer those.
It doesn't look like we have any questions yet. If you do have a question, please type it into the chat.
Anything coming your way?
It doesn't look like it. So in that case, we'll go ahead and conclude. Thank you, everybody, for joining us today. Thank you very much, Jason.
Yeah, you're welcome. Everybody, thank you so much. Thank you for the work you do. It's challenging work. Family law is a challenging area. It's an area that uh, can be complicated, but at the same time, it can be really rewarding. If you have any questions about anything that I've talked about today, my email address, phone number are here. Happy to chat with you anytime. I just wish you all the best of luck, and we'll see you in court.